Hello, Brian Weeks here again with another MMCD contract consideration. This video clip will cover the topic of partial versus staged substantial performance of a construction contract. In this short video, I hope to clarify for you the difference between what I call partial substantial performance, which is illegal, and staged substantial performance, which is permitted in British Columbia. Currently, the Master Municipal Construction documents are written exclusively to suit the laws and regulations applicable in British Columbia. One of these laws is the BC Builders Lien Act. Now, I need to be clear that I'm not a lawyer, although I've had extensive discussions with lawyers on this topic. However, because of the ever-changing nature of the law, given court decisions, anyone with a significant concern regarding liens, holdback, and holdback releases needs to get up-to-date legal advice from a lawyer. The BC Builders Lien Act was extensively modernized in about 2000. One of the changes was a new ability of subcontractors to claim for substantial performance independently of the head or general contractor. This created what I call staged substantial performance, although this is not a term used in the Lien Act itself. First, let's talk about contract completion. This is a term defined in the Act, and it is based on a proportion of the contract price remaining to be paid out. The calculation is quite simple. 3% of the first $500,000 of contract value, plus 2% of the next $500,000, plus 1% of the balance of the price. I call this the 3-2-1 test. While simple, someone has to do this calculation. This person is called the payment certifier in both the Act and the MMCD. The contractor or subcontractor applies to the payment certifier for a certificate, and the payment certifier values the deficiencies in the remaining work. If it meets the numerical monetary test, then the project is complete for Builders Lien Act purposes. Then, a number of things are triggered. Appropriate notices must be posted. A 45-day clock starts running for any final liens to be filed, and a 55-day clock starts running for release of all holdback funds not needed to cover the filed liens. As a note to clarify terminology, substantial performance is an MMCD term which requires both the contract to be completed for Builders Lien Act purposes as well as, quote, the work or a substantial part of it is ready for use or is being used for the purpose intended, close quote. Note that the second part of this definition, that is, the part about being ready for use, cannot be used by the payment certifier to delay the issuance of the certificate of completion for Builders Lien Act purposes. So, who then is the payment certifier? Section 7 of the Act requires someone to be designated as the person who has the responsibility to determine if the project or contract is completed. However, it allows the owner to designate someone to fulfill this role, and that person has the title payment certifier for the purposes of the Act. If the owner does not delegate the role, then the Act makes the owner the payment certifier for the general contractor, and the owner and general contractor jointly hold the role with respect to subcontractors. But using the Act's flexibility through MMCD General Condition 18.6.6, owners designate the contract administrator to be the payment certifier for the general contractor, and they also designate the general contractor to be the payment certifier for all subcontractor work. While this delegation is both legal and implemented under our standard MMCD conditions, it has implications for the owner, CA, and general contractor. In a municipal environment, while the owner is solely responsible for maintaining the holdback account, the owner is obliged to release funds from that account not later than 55 days following completion of a signed certificate of substantial performance by the CA or by the general contractor in their roles as payment certifiers. Let's be clear on that. The owner does not have the right to overrule the decision of the payment certifier. Doing so would create the basis for a legal challenge. In particular, when the contractor submits a certificate of substantial performance for a subcontractor, neither the CA nor the owner may circumvent or delay full payment as certified. Similarly, with the delegation of payment certifier status to the general contractor for all subcontracts, the contractor must know and abide by all requirements of the Act, or may face the significant penalties which can be imposed under the Act. The owner can take some comfort in the fact that a staged substantial performance by a subcontractor does not relieve the contractor of the requirement for full and strict compliance with all contract terms and conditions. The very first clause in the agreement between the owner and the contractor says, quote, "The contractor will perform all work and provide all labor, equipment, and materials, and do all things strictly as required by the contract documents." Close quote. There is no agreement between the owner and any subcontractor, and the contractor cannot assign this responsibility to anyone else without the owner's express written permission. Similarly, the owner does not care about substantial performance of parts of the contract. The only date that matters to the owner is the date of substantial performance by the general contractor as certified by the contract administrator. This is the date that allows the owner to take over and use the project, and it is the date that starts the warranty or maintenance period clock. So, while staged substantial performance will reduce the amount of funds in the lien holdback account, it does not alter the general contractor's obligations to the owner. So, what is this partial substantial performance that I mentioned at the beginning of this video? First of all, let me say this is a term I made up. It is not defined in the Act or the MMCD. Nevertheless, the situation does occur. To explain it, let me use an example that happens in BC fairly often. Say that the project requires 2 lifts of pavement to complete the paving requirements. Suppose further that due to early onset of bad weather or legitimate job delays for changes or extra work, the second lift of paving cannot be done in the fall and must wait for better weather in the spring. In this circumstance, contractors will often approach the contract administrator and ask if the CA can release part of the lien holdback funds, that is, those which have been held for work that's been completed and already accepted. Often, the cost of the second lift of paving exceeds the 3-2-1 test under the Act, so a completion certificate or a certificate of substantial performance cannot be issued. On the face of it, the contractor's request seems reasonable. Unfortunately, it is not legal to comply with this request. The reason is that the funds are not necessarily due to the general contractor. Lien funds are held in trust for subcontractors and suppliers to the general contractor. Without a certificate of completion being posted, these potential claimants do not know the trust funds are about to be released. Hence, their protection would be reduced without their knowledge. In fact, releasing the funds improperly could leave the owner liable to top up the fund to the amount it should have been had the improper payment not been made. Because the Builder's Lien Act does not provide for partial payments to the general contractor, the only way to release holdback funds to the general contractor, if that's what the owner wishes to do, is to alter the contract such that the 3-2-1 test is met. The owner can instruct the CA to delete sufficient value from the work remaining that the test will be met. Once that occurs, the contractor can apply for a certificate of substantial performance in the normal manner, and the normal inspections, deficiency calculations, and timelines will apply. Specifically, once the certificate is issued, the 45-day and 55-day clocks start to run as set out in the Act. This method, however, leaves the owner in a quandary. What about the deleted items? Who will do them, and what will that cost? Usually, the owner wants this contractor to finish the job. So, as part of the negotiations concerning terminating the contract, the owner will want to get a new contract drawn up, which will, number one, commit the contractor to return and complete the deleted items at the same prices as tendered for the original contract, but with a new completion date. 2. Prevent the contractor from claiming for quantity underruns on items deleted from the original contract as a result of this change. 3. Clarify any changes in the start of the maintenance period. And 4. Define who's responsible for any extra costs incurred in having two contracts. One potential snag to using this method is that some municipalities have bylaws or policies which preclude awarding a significant contract without tendering. If the owner is sympathetic to the contractor's problems concerning those who want to be paid, there's another partial solution. While it does not help the general contractor with payments due for costs incurred directly, it can reduce the pressure on the general contractor from subcontractors who are looking for holdback funds. The solution is to use the concept of staged substantial performance as explained earlier. Once their subcontracts are completed, the subcontractors can apply to the general contractor for release of their holdbacks. Then the general contractor must act as the payment certifier, process each request, and if the Builder's Lien Act test is met, approve the request for holdback release. The owner must then release the funds so certified at the 55-day point. To summarize, the BC Builder's Lien Act enables subcontractors who have completed their work to apply for release of any related holdbacks prior to completion of the head contract. I refer to this as staged substantial performance. 2. Partial substantial performance is the term I use for an illegal release of part of the holdback funds prior to issuance and posting of a completion certificate. The Act does not allow this because the holdback funds are being held in trust for potential lien claimants. 3. The Act requires someone to be the payment certifier who judges whether the contract has been completed. The MMCD takes advantage of the Act's flexibility to designate that the CA is the payment certifier for the general contractor only, while the general contractor becomes the payment certifier for all subcontractors. This delegation removes the ability of the owner or the CA to dispute or delay release of holdback funds approved by the contractor. However, it does not change the contractor's obligations to comply fully with all contract terms and conditions. 4. In some circumstances, owners may be sympathetic to a contractor's request for early release of holdback funds. The owner has only two legal ways to accommodate this request. A. Reduce the scope of the original contract to enable normal substantial performance to be attained. This may require an additional contract to ensure the contractor completes the balance of the work later at the original prices. Or B. Encourage the contractor to act as payment certifier for completed subcontracts, although this does not assist the contractor with costs incurred directly. I hope this has helped clarify this contract consideration. Please check our website for further assistance and to see what other topics are presented in this series. Thanks for watching.